good afternoon to everyone over here in China, Australia, and it's an early morning for you. Is that right, Mark?
No, not really. It's 8:30. I
Oh,
have been up earlier than this in my life.
well, I'm glad you're here, and hopefully you got your coffee in you.
I already have, yes. Thank you.
Good, good. All right. So this is actually episode 18. This is a continuation of the previous episode. Uh, just a little bit of house cleaning like usual. We're kind of going based off of Mark's oh classic text, China: The Art of Law, and we do have a YouTube channel which everyone who's registered for this webinar, I'll send a PDF, a copy of this presentation, but you can click that link and you can visit the YouTube channel. And if you have any questions, just go ahead and shout it out in the chat. I keep an eye on the chat while Mark is talking. I try to make sure that he gets to all the questions at the right time. So with that said, on the previous episode, on part one, we were talking, so negotiations is a kind of a broad topic, which is why we wanted to break this into a two-parter. We talked a little bit about preparation. What is your stake in the partnership? What are your roles and objectives? What is your partner's role and objectives? And who are the other stakeholders in a partnership besides just obviously the direct partner? We talked about finding the right partner. So what is legally possible in terms of structuring the partnership? What are the challenges that Chinese partners might face when working with international companies? And a little bit about letter of intent as well. And for the due diligence part, we gave a nice case study showing how the perfect partner can prove problematic. So again, the PDF will be emailed to everybody, and the link to the first part is on this slide as well. So Mark, in your book, you did mention this article, and we talked about this before in a previous episode. And I just thought it was super relevant for this part, since in this part two, we're actually going to go a little bit into more of the nitty gritty on negotiating and putting all of the terms onto paper. So to their credit, this is the authors were writing from 2003. So I did want to ask you. What were your views of this article back when you wrote the book, which is around the same time as the article, but also, what are your views today? And, have they changed? Have they remained the same?
Yeah, well, I mean, I guess it's a problem. I've never been an author for the Harvard Business Review. So, but I must admit, back in 2003, when I bought this at the airport, it was a book about doing business with China. I don't know if I've still got it somewhere. I have to have a look for it. But there was this one article, and it was about the Chinese negotiation. And it was the most stupid thing I've ever read then. And it is still the most stupid thing I've read since. And I think, it was an interesting article. Did you find it, Sean? Is it able
yeah,
to
the link is right there on the bottom. So whenever people,
well, you should send everybody a copy of it, because it is. I thought it was hilarious. It was really talking about how the foreign party should just fully hand over negotiation to somebody Chinese who doesn't know their company and will not actually translate what they say. So I just thought it was ridiculous. But my favorite part was their mini case study, where it was an American software company from memory. They wanted to get a distributor in China, and the Chinese distributor wanted to own the software in China, which seemed to me to be quite a big ask for a distributor back in 2003 or whatever. But anyway, nobody could solve it because the Americans said, no way. And then they got some Chinese interpreter guy in, and the solution was that the Americans and the Chinese distributor, who hadn't proven himself to do anything, would co-own the software in China. So, I guess, I could be that Zhong Jianren, or the middleman as well, if you would just let me agree any stupid thing you want. So I guess that article, I think, is silly. The other great thing, which has changed a little bit, I think, was it was talking about how Chinese negotiators, no matter how well prepared you are, the Chinese negotiators will be better prepared. And back in 2003, this really struck me as a surprise, because I remember we had a Swiss client who was building a factory in Kunshan, I think it was. Anyway, we went to the meeting with the two construction companies that wanted to build the building. And the Swiss had spent hours doing a very detailed proposal. And the first guy came in, and all he had was a pencil. He didn't even have a piece of paper. He just had a pencil. So he took a piece of paper from me, listened, looked at the proposal, and then just said, like, I think it was like 6,000 renminbi per square meter construction cost. And yeah, the Swiss were doing this kind of machinery that like was stamping. And so you need to have very deep foundations. Otherwise the building would sink and all this kind of stuff. And like Kunshan's basically built on a swamp. So anyway, the guy listened and he just said, he just got a pencil, wrote 6,000 RMB. I thought, geez, that's strange. And then the next guy came in and he was exactly the same, but he didn't even have a pencil. So, I think, this idea that the Chinese partners are all super, super organized, it didn't jibe with me. But anyway, yeah, that was my rant.
So fair to say
even 15, or what is it, 17 or 18 years later, this article still drives me crazy.
Okay. So in your experience, so you don't have a list of Zhongjianren that you can speed dial for the negotiations, I assume.
Yeah, I think it's always difficult. There's always a role for people, but I think one of the things they say in here is they settle the differences, and you just don't tell. They don't really talk directly. But I think really, if you're doing something like a joint venture or you're doing an acquisition or something, you're gonna have to talk directly to the Chinese partner. It's no use, pretending the relationship is something which it isn't. I mean, and my experience has been the Chinese partners are very happy to talk directly when they're upset. So,
Yeah, I would think so.
to have a direct. Yeah, I think, there's a bit of a cultural overlay, but I think we shouldn't overdo it. I think people are pretty,
And the reason why I rehashed this slide is because what we're going to talk about today is a little bit about commercial negotiations, but of course, like you said, there's a little bit of culture context embedded in this whole thing, which we will touch on. But it's not like this article says, it's not the driving factor. The deals are not being made or broken based off of your your understanding of culture. I mean, business is pretty much universal. So if it was if it wasn't that true then 18 years later, I can't assume that it's even more true today. So we'll talk a little bit about this will be the first part on term sheets, but we'll also talk a little bit about the actual negotiations, and we'll finish off with the the actual agreement, the contract itself. So before we get into the term sheet, Mark, maybe you just want to explain what is the lawyer's role from this, because in part one, it was kind of the preparation that an international company should probably do from their own side, then without reaching out to outside counsel or any external parties. This is just kind of their strategic positioning. But once it's ready to actually get into something like a term sheet, for example, is that when you think like maybe a lawyer should join, or you should start getting involved?
Yeah, so maybe this slide is actually misleading. This slide, I think, was originally in like a supply contract, which is often done by engineers. I don't think many engineers do the term sheet for an acquisition or a joint venture. So now that I see it and I'm actually speaking about it, I think maybe it's a little bit wrong. But I think what we could have done is perhaps have that fancy car, a Passat, and the other car with the cow. Yeah. So I think the idea is sometimes when we're looking at M&A deals, if you have law firms from overseas and they often design these contracts that are far too complicated, don't work in practice. If the client does it themselves, they'll often just have it like that, the cow with the thing there, which is also just too simple, doesn't see the problems. So probably the best is actually a Passat rather than the very, very fancy thing. It's probably better just to have the contract that is understandable. You know, I've seen contracts from American lawyers, and there were really pages I did not understand. I mean, in English, I did not understand what they're talking about. And then, you know, very often, I mean, I'm sure people know this, but yeah, lawyers, they do work with template contracts. And, you know, someone who's a bit scared or doesn't really know the area very well will stick very closely to the template. And people will often think that, you know, a contract, if it's longer, it'll be more impressive for the client. And maybe some clients think that as well. But I think it was Oscar Wilde who said, you know, sorry for the long letter. If I had more time, I would have made it shorter. And I think that's the important thing. Yeah, the contract, it should be, you know, strategic. It should be written as long as it has to be, but no longer. And it should make sense. It should be something that somebody could read and understand. And I think most contracts I see, you know, done by many lawyers, you know, unless you're really in it, you don't understand everything. And the problem is the likely disputes will be 10 years later. It's not going to be likely in 6 months. It's normally like 10 years later. And if nobody can remember what was happening, it makes it difficult.
Yeah, and I think what you were talking about is kind of like the very high level view of, I guess, from a lawyer's perspective. But my understanding of a term sheet, and this is, and maybe we just go a little bit microscopic for a second. You know, is it like the egg, the conception of the contract? You know, what is a term sheet for someone who is and you know, what is the importance of a term sheet, I guess, in context of the overall contract and you know, the relationship.
So at least, you know, like our wording, what I would do things is, you know, if we're talking about doing a joint venture or doing an acquisition, maybe just to see if people even have the same idea, maybe to unlock due diligence, we would have a letter of intent. So there's at least something formal which is signed to show that people are kind of halfway serious. And then I think the term sheet is normally post due diligence. It doesn't have to be, it can be, but you know, at least post very serious discussions. And I think the term sheet, the goal is within 4 pages or 6 pages at the most, I would think, you can agree all the major issues. So, like let's say it's a joint venture, that makes it easier. Yeah, what are the shareholding ratios? Who, you know, what is the board composition? What's the business scope? Is there exclusivity? What's the capital going to be? You know, who's in charge of which part of the management? Yeah, these kind of issues, which, you know, if you can't agree, then it makes no sense to proceed. So I think that, yeah, in essence, the term sheet should be this 4 to 6 page document that hits 95% of the difficult issues. And if you can't agree that, it's no use getting a contract of 50 pages or, you know, 40 pages drafted, translated into Chinese. Which items should be reserved for the final agreement? I think the final agreement, you know, ideally should be more just wording, but it could be stuff like, say, the call option or a put option or an exit termination. But let's just say, for example, that the, you know, foreign shareholder will have a call option after 3 years or something. That would be enough for the term sheet. Then in the final agreement, you have to like put in the details about how that would operate, how it would be priced, all these kind of things. I think the term sheets, they're not really normally, at least I would never tell anybody they're enforceable, because the definitive agreement, yeah, will be too complicated. I guess if you're a purely legalistic view, you could say the confidentiality or other terms could be enforceable, but who would go to court to try to enforce a term sheet confidentiality? I don't think that would happen. So I think, you know, it's really the idea, and I would wait for the DD ideally if you're buying the company, because I think the term sheet really should be the document upon which you could draft the joint venture contract very quickly, or the sale and acquisition agreements.
So one of the big issues that touched on in the first part, and also we'll touch on in this part as well, is the exit. Kind of like you said, how does it all end? Obviously, there should be some thought about that. But the term sheet, do you think I think you said that it's probably not the right place to start inserting that, because because the term sheet is just kind of a way to kind of like get the parties together and working together, getting that team spirit, or is that the main reason for that, or is it just not is it just too early to discuss those types of things?
I think it's I mean, it's like, I think it's bad karma. I think, I always tell people, think about how you get out of the joint venture, or the acquisition, but a lot of that will not be included even in the definitive agreements. There will be strategic ideas how to distance yourself. It may well be, let's say in some extreme examples, you invest via a SPV, or maybe you don't even put your company name in the company. We've done this in a few more extreme cases, and in each case it was actually a very good idea. So I think that's one of it. Secondly, I think like I said, most contracts are templates, and termination clauses, I think they're very rarely negotiated. But termination clauses, people don't focus on that. So I think it's important to have an exit, but I think mostly, and we're mostly dealing for the foreign side, Chinese partners don't discuss about that. Chinese side will talk, hours and hours and days on end, and also the foreign side, about reps and warranties, even though they're a little bit more likely to go before a court, but still very unlikely. So yeah. I think the termination's even more unlikely. It's in what 25, 30 years of doing this, I think we've seen one case where somebody went to court about the termination, and of course that didn't get a judgment. It was settled in the middle of that. So I think that shows you, how to deal with that.
Yeah, I agree. It can be a little bit awkward. But do you at least recommend that? How early should people start thinking about the exit? Just you don't have to negotiate it, but should they start thinking about the exit while they're planning the term sheet as well, from a strategic standpoint?
Well, I think it would depend. I mean, it's not just the term sheet. You have to think of it early on, and it really will be a bespoke issue. So let's say, for example, if you plan to do this joint venture and you plan to do it exclusively, you have your technology. Well, how do you exit that? I mean, that might be more in the technology license agreement, might be the patent rights, it might be how you deal with those kind of IP rights or the distribution rights. So I think it's going to be very much what your case is, who you are, what your plans are for China, what's your backup plan. So it's a bit difficult. I think the term sheet, it would be unlikely that you can, just have a sentence which says, this is how we get out. And the exit nowadays, I think we said in a previous episode, we're talking about, most joint ventures never have a plan how they exit. They just think, okay, we're in. But nowadays, we do see people who want to do a IPO in China or Hong Kong, or they want to sell to a strategic. But still, most companies who go into joint ventures don't really know how they're going to leave. So the exits I'm talking about is more, the parachute rather than the preferred option. It's more, how do I get out of this joint venture if I'm in trouble later?
Right. So this slide kind of gets to that point a little bit, because protecting yourself is, I would hope, something that most of the the clients consider. Maybe it is, like you said, bespoke, but there is kind of like I guess of a song and dance. You don't really want to address these types of issues so explicitly, especially early on, term sheet or for example. But there are still ways that people can still think about how to protect themselves.
Yeah. So I think here, we don't have to go through all this in detail, but I think the idea is really the wording needs to be clear, and a lot of people fudge things, and that's okay. I mean, if they have to, they have to. But let's say, for example, my most common preferred option to give us a bit of a leverage is how can we exit? And that might not be, that might be in the term sheet in the form of like a put option. And, maybe we would say the value is, if certain thing is triggered, which isn't too complicated, you could say like after 2 years of loss or something, then the foreign party has a put option and the Chinese side has to buy it at its registered capital or at the book value or something. Something like that is good to put in if you can get away with it. So I think this is the idea. The term sheet shouldn't be too detailed. And I think a lot of those kind of solutions, it's not feasible. Like I saw one a few months ago where a law firm, American law firm, had done this document, and there was a 3-page termination thing. And it was like you go to Price Waterhouse, there'd be 2 envelopes, there'd be, they called it a shootout clause, and then people would do the, both sides would have another valuer each, and then if it's within 10%. But there's no way anybody's ever exchanged envelopes. I think, so I think you have to be not just what you think is really cute and clever and fantastic, but you have to be a bit reasonable. What could actually work in the heat of the moment? That's the issue.
Yeah. And we were talking a little bit about exits and protecting yourself, but it is important to keep in mind, and this is something you're quite a big proponent of, and that is, these types of agreements, this is not an adversarial process. This is a cooperative process. So, the 2 parties obviously have self-interest, but, they also have a joint interest as well. So the contract should, even starting from the term sheet, should have some cooperation, I guess you could say.
Yeah. So I think here, we've got a case at the moment which is exactly like this. And this is why I sometimes really don't like lawyers as well, but also sometimes don't like clients. So our client is a company that wants to, they want to get the core technology from overseas and then develop it in China, but nobody knows if this will be successful or not. So on day one, the client had mentioned that they had agreed with the overseas company that basically the overseas company would grant an exclusive license to the core technology, and and then they could develop it. They would the entity in China or the offshore entity would own the improvements and maybe license it back to the international company. Okay, so far so good. That makes sense. And if certain milestones are reached, like if they get a certain level of business in China and they want to perhaps IPO, then the core technology for China, like the China patents, would be transferred to this entity, which the foreign company would also own shares in. So I understood that. And, unfortunately, I was the only one who seemed to understand this, because we had to wait for months for the international lawyer to do the technology license agreement. And, it's always frustrating when you get a document that people have been working on for months, but they ignore what the clients have agreed. And so, and I knew this was going to happen. So basically, this technology license agreement was just a license. It was only exclusive for the patents, but not the know-how. I don't know why. And also all improvements would be owned by the international company. So really, it was pointless. It made no sense. And then I'm discussing with the client more about what their concept was and how we could do that. And then he kept on saying, well, maybe they should transfer the core technology immediately anyway. So I think this kind of stuff is just stupid. And so, I understand where you have an adversarial approach in criminal proceedings. So, Sean, if you were up for murder, I understand you would want your lawyer not to be too friendly and, you want to not go to jail. The other side might want to put you in jail. I understand that. Or even in litigation, I understand that. But really, for this kind of collaborative endeavor, it's kind of annoying where, especially if it's not very big companies and you have the two, let's call them entrepreneurs discussing things, and then the lawyers both seem to know better and just do things totally differently and one-sided. How do you ever land? That's the query. And so I think the one-sided contracts, they're so difficult to negotiate. And I would say they're time consuming. It gets bad will because people feel like they're being ripped off or whatever. And, instead, the lawyers, instead of saying you can do this, these are the risks, the lawyers just draft ridiculously one-sided things. And it makes the actual parties' intentions unclear. In that technology license agreement, everything was to the benefit of the international party. So, yeah, what do they really want? That was unclear to me. And then I think the thing which I'd also would say is often the things that you negotiate the longest are the most impractical and most difficult to enforce. So we were working on an education project for a British school, and the previous lawyers had drafted this provision because there was like a rollout of schools. So if they just did one school, it wouldn't have been very interesting for them. But if the Chinese partner was able to open 5 schools, it would be a successful business. But their lawyer in England, because he's smarter than everybody else, he had this long provision that if the Chinese partner did not open up those 5 schools over a 3-year period, they would pay phantom licensing fees. So it would be as if you did have 5 schools, but you only had 1 school, you'd pay the license fees if you got 5. Beautiful, very tricky idea. But does anybody really believe that the Chinese partner is unsuccessful with 1 school? Probably the business is bankrupt. Is he really going to hand over the license fee as if it's for 5 schools? Is it possible? Could you enforce it? Would you go to court to do this? Yeah. This is what really is annoying, is people would destroy perfectly good deals by asking for fantastic unicorn-like solutions.
That sounds like a bad deal.
Yeah.
So we'll get into the second part here then, Mark, which is the negotiation tactics. And I think for this part, it's a little bit, that first part was more about, making sure that the parties are aligned in terms of the contract, but starting specifically from the term sheet, starting from the get-go. When in this part, we're going to talk a little bit more about the actual, I guess, art of negotiation, so to speak. And you kind of touched on this, some of this stuff here already. I find it funny that the negotiations, in that last example, not the school one, but the one before that, it seems like they would have negotiated at least some of those basic principles, but then, it comes back totally different. So it just ends up wasting a lot of time, and probably that lawyer ended up charging a little bit of extra, or, I don't know what, something happened along the lines where the message was lost. So here are some tips on, negotiating.
So one of our clients, his name was Jos Kurter. He was a smart guy, and he once told me at a meeting, he said it was very interesting when they would do like a board meeting minutes. He's always surprised, they would send it to the in-house lawyer just to double check, and the in-house lawyer would insert paragraphs of things that had never been discussed at the board. And he always found that was very puzzling. So I think, it's not exclusively a Chinese issue. It's kind of a strange thing. So I think preparation's key. I think it's an advantage for the foreign side in particular, because many Chinese counterparts won't be that prepared. I think bilingual contracts are important. Maybe 1 in 100, you will see that the Chinese party is happy to do an English contract, but it really is 1 in 100. It's really, even if you negotiate the English, which might be 5 in 100, I think in most cases you'll need a kind of, if it's a purchase agreement or a joint venture or that, you're going to need a Chinese version anyway. I would say that it's, what I always would do is protocol the meetings. So, because very often, you have this meeting, you think you've agreed things, and then, time elapses, and, sometimes also the foreign party changes its ideas, but then the Chinese company will often change its ideas. So what I would do is I just do a protocol, who was there, the dates, what is the result, and then I would attach the contract and mark in yellow the open points. Now, this is not going to be enforceable, but it at least shows that anything which is not marked in yellow kind of was agreed. And I think that narrows the conversation. I once was in our Australian office, and they happened to have this meeting with one of their big clients who's doing a lot of like construction contracts in China. And they asked me, oh, do you want to join? I joined and I listened. It was about doing contracts with Chinese parties. So they asked me at the end of the presentation, the construction company is very surprised that, that a lot of their contracts were really bogged down and slow. So, they would sign in Australia in a month would take like 9 months. And I said, well, what's your process? They said, well, we would do a call, and then we would, update the contracts. We would send the originals by courier, and then we wouldn't hear anything. We'd have to phone the Chinese partner again and follow up, et cetera, et cetera. And I said, well, that's very surprising. And he said, oh, it's surprising that the Chinese company doesn't respond immediately. I said, no, it's very surprising that you've ever signed a contract with this approach. So, I think, really try to get it signed at the table. In the good old days when people were meeting in person, and especially with things like joint venture contracts, most of our contracts were signed at 2 o'clock in the morning. And then I think what we introduced, because I saw Jerome asked a question about a difference between English and Chinese version, we introduced like a 48-hour cooling off period just to check the Chinese against the English. Because I don't think, I haven't come across the person that wants to benefit from that. And, things haven't been submitted or whatever. So I think it's really important to get it signed at the table. Otherwise, people always unpick things. I think, analyzing who the real decision maker is on the other side is important. It's often, if it's a big state-owned company, it's difficult. Probably the real decision maker is never at the table. And, I think you don't lose your temper. Sometimes people lose their temper. I sometimes lose my temper on purpose just to pretend to be upset, just to get people a bit excited. But I think, good humor and constructive discussions is better. I remember we had this one negotiation that was going on for a long time, and I had seen this YouTube video a few days before of this Indian-Canadian comedian who was talking about an Indian and a Chinese trying to buy something, at a market. And basically the Chinese guy wants it almost for free, and the Indian guy wants to get as much as possible. And he keeps on shouting at the Chinese customer, be a man. And anyway, I started then just shouting to the Chinese lawyer, whenever you make some kind of ridiculous comment, I just say, be a man and agree to that. And the Chinese thought this was hilarious. And, so if you introduce a bit of gameplay into it, it makes them happier and they, get more boisterous. I think, it's good to have a bit of banter in the conversation.
Yeah, get back to the team approach.
Yeah.
So, so the strategic considerations that go, I guess, when you're walking into a negotiation or when you're sitting across from your, potential partner. I mean, there are still some, I guess, consider like you mentioned, finding out who the real decision maker is, finding out who is your partner, and then how does that figure into, how the negotiations may play out, or how you may, anticipate the negotiations to be. We don't have to go through all of these, Mark. It would probably take too much time. Maybe you want to just pick a few of them, but do you, for example, if you're walking into a negotiation with a SOE, for example, is it going to be different than if you're going to walk into a negotiation into a private enterprise, or even, let's just say, for example, a private enterprise that is pretty big in that town? How these are, I guess, these are the different types of considerations that we're kind of getting to here.
So I think, let's just say the state-owned enterprise versus a private company. So I think a state-owned enterprise, you would expect it to be much slower decision-making. You would expect it to be about, issues that most foreign companies wouldn't think are so relevant. It would be perhaps also who is your partner within the large state-owned enterprise, things like that. Very often you'll have more complexities about procurement and tied sales and, maybe, distribution to the army or something. I don't know. So I think, that's a lot of issues. Also, a lot of issues about, what happens if it goes wrong. Because with a large SOE, it's really harder to get out of than a private enterprise. Because if you think it's hard for them to make a decision to enter a joint venture with you, it's much harder for them to make a decision, especially if it's after 10 years, to leave the joint venture, or to part ways. Because whereas the Chinese partner is a local private enterprise, they'll be much nimbler. They'll make the decision. It'll be often price. It will be often be what IP rights. It'll often be these kind of things. So it's much more of a commercial decision. So that would also be the exit. Like, well, how can I get out of it? So for example, how to protect our IP in this joint venture. State-owned or private enterprise, you might need to think of different ways how to best deal with it. I think the other one here is about operational role in a joint venture. We have a lot of people who, I understand, do fight. Like, people fight and fight to say, I want the general manager. And then, they've signed it. They've been negotiating for 3 years. And then, they'll come to me and they'll just sign the joint venture contract. And a week later, they say, hey, do you know anybody who could be the general manager? I said, but you've been fighting for 3 years. I assumed you must have had somebody in mind. I said, no, we don't know anybody. So, I think the thing is, think a bit about, before you negotiate, what is your operational role? Will you have people in there? And I think the world's changed. So I think, I expect we'll have more joint ventures where international companies will contribute technology. Maybe they get 25%, 30% or whatever, but the Chinese side runs the business. So it's different. So before you do the term sheet, before you do the joint venture, before you think the exit, all these things, just try to work out, who are you in this? And I know it's hard to give up, because people on the one hand say, look, we'll let the Chinese run it. But then when they look at it, they say, well, but we want the general manager and the CFO. Yeah, it doesn't work that way. So you have to really think a bit about, what will happen.
And I could assume that a lot of those answers will change depending on, some of the other stuff in the different boxes. What is your role if you're cooperating with a SOE might be totally different than if you're cooperating with a private enterprise.
Well, that's a good point. Just briefly on that. I mean, it's an interesting point. Another guy who I know, Peter Hopp, who's a lawyer who's been dealing in China. He's German. He works for Rio Tinto now. But he also said a very interesting thing to me about 15 years ago. He said, the interesting thing is with these joint venture contracts, people negotiate them and they're so static, like it lasts for 20 years, where it would be better if you renegotiate the business plan every year. So I think with the joint venture contracts, we try to make them a little bit flexible so that they set the framework, but not everything is inflexible. And so I think that's the problem. Whenever you have a problem with the joint venture, people will look at the joint venture contract like it's the Constitution of America, and all the answers will be there because of the wisdom of these founding fathers of the joint venture. And it's strange. After 10 or 15 years, very often it doesn't really have the answers to the problems.
Yeah, that's a very good point. And before I move on to the next slide, I'll just read out Ban's comment very quickly. I guess this is related to the ultimate contract, which we will get to later, but I know we didn't put this one in there. One language, either Chinese or English or another language, will be the legal one, and then the other one will just be kind of for reference. Is that usually how it happens, Mark?
Yeah, I think nowadays you're not going to get away with, if it's something that has to go to the Chinese authorities and it's a China-centric contract, I don't think, years ago, which I also never thought made sense, but people had the Chinese partner agree, would be that the English one would prevail. And I think this is like 10 or 15 years ago, Chinese authorities said, we're not having that. I think for most contracts, you can have them, what's the word for it? Like mutually, they're equal validity. Most joint venture contracts or SPAs will have arbitration. So what I draft in is we say something like, both English and Chinese are equally valid, etc. The parties negotiated on the basis of the English version. And so what would happen is yeah, most translation errors will be, I mean, I haven't seen any. I mean, there's two buckets. There's the crazy one where they just did a Chinese version and English version, which are different because the two sides wanted something different. So that's a crazy one. But yeah, often it will be something like the numbering, because Chinese think in tens of thousands, Europeans think in thousands. So it's something like that. And then if it would go to arbitration, it would be normally, well, did they mean 1,000 or they mean 10,000? And if it was not clear, I put in this thing saying about the English version was the base of negotiation, because I'm hoping, but it's only a hope because I don't know if it's going to work in practice, but the arbitrators would really say, I don't know if they meant 1,000 or 10,000. I really don't know. It's not clear from the facts. So I guess my default is they said they negotiated on the English version. So since it's a clear inconsistency, then probably the English is the true intent. So that's how we address it. But I think the most important thing is to make sure you check the English and Chinese. And that's why we have that cooling off period, if we can get away with it, just so somebody else with a fresh pair of eyes can check. And that's why we also, I don't like separate English and Chinese contracts anymore. I prefer to have them in one document, because it could be that one isn't updated. It increases the risks. That's why.
Yeah. And I think we've mentioned this in previous episodes, but it, like you just said, if there is an exit, sometimes it might just be people that were not involved in the actual negotiations for entering the agreement. So, these types of little, hints and clues, they do have some value, especially for the successors later on, which we will kind of get into in another slide. But Mark, very quickly here, because we do have a lot of slides still to get through. We can't avoid. We foreshadowed that there are some cultural, I guess, aspects to the negotiation. We're not saying that this is how all Westerners are and how all Chinese are, but this is just kind of I guess, what you've seen from your experience. Is that right, Mark? Maybe you want to help us go through the next couple of slides.
These diagrams, we should put somewhere where these diagrams came from. So it was a Chinese artist living in Germany who came up with them. So they're not ours. So actually, Sean, going forward, we should attribute.
Oh, I didn't know that. Okay.
Yeah. So we didn't develop these. I think, the issue is, I think often Westerners, as you say, these are just basic feelings, not everybody. But I think Westerners think negotiations will be quicker, so they underplay cultural issues, preparation issues. They often will think if something's been agreed, it's been agreed. And, I think the Chinese side will sometimes not have a clear understanding what they're negotiating. So that's one issue. And that's why it's important to trap them. And you often don't know who is the decision maker with the Chinese side. So they often will report back. And I guess, one of the other problems is, the Westerner will say, do you agree? And the Chinese side will say, "可以" or something like that. They'll say something which the Westerner thinks means they agree, but it probably might mean I agree, or I heard what you said, or I understand what you said. I'm not sure what you said. And so sometimes people just assume, because I think culturally Chinese people like to agree with people and stuff. That can cause problems. I think this is also perhaps German companies in particular. It seems they will, when it comes to a problem, they do like to run at that problem, and part of that is because I think the German companies, when I've seen them, they have a group discussion. They agree everything, and it seems to me very often it's difficult to divert from the plan because so many people have agreed the plan, even if there's a big hole in the way. So they must continue to progress into the hole. Where the Chinese side might think, this is a bit difficult, we'll solve it later. As the relationship builds, we'll deal with it. So I think the Westerners would prefer to have the problem solved. And I must admit, I also think it's better to solve the problem, especially for the Western side, because once you put the money in and you're operating it, the Chinese partner, their position will normally strengthen in the joint venture. And so, about the boss, negotiations are not egalitarian. Western companies, there might be one person, but even the big boss, very few examples. Maybe it's a big privately owned company. Somebody is, very powerful in the thing, but normally they what do you call it? They hand off power to other. They what's the word, Sean? When you delegate, they delegate power to others. Whereas in Chinese companies, I've often found that the consensus approach is really trying to work out what the boss wants, and so this can be difficult. So I think it can be complicated, especially if the boss is not at the table. That's why some things are not agreed when you think they're agreed at the table.
So this next section is, Mark, maybe we have to go a little bit fast, but this is kind of one of the biggest topics, of course, is the contract. So we've done the negotiations, we figured out the term sheet. Now we're actually getting to we're at the last mile here where we're just trying to get this contract together. Maybe let's just go over very basic, what are the main issues that need to be addressed in the contract?
Okay, so I guess the first one's like contributions, like is it a 50-50, 60-40, 70-30? That ties into how much you have to contribute, but also consolidation. So if you're dealing with a state-owned enterprise that's listed, or a Chinese privately owned enterprise that's listed, they will probably want to consolidate, which means they have to show control, which means they'll probably want 51%, plus they'll want certain rights in the board. And often they may not fully know what they want at the start, but as it progresses, if it's a listed company, the auditors will get involved and then they'll need more control. So that's important to know that issue about consolidation. The scope, which I mean there is the business scope, that's important. And also it ties into what the company's going to do. Will you give them exclusivity? Will they be the only entity you do in China? All those kind of issues. Management's another important issue, like who is in the board. If it's 50-50, normally it'd be like a 2+2. Who will have the chairman? In a joint venture, who's the legal rep? Things like that. Appointment rights, it tends to be, in the old days, if it's a roughly similar joint venture, maybe the Chinese partner would have the chairman and the foreign partner might have the general manager. But other important roles are like CFO and procurement, things like that. Dealing with a deadlock is important. Again, it doesn't really work before a court, at least I haven't seen it. But I think if you have the right kind of simple but thought out deadlock provisions, they can help you diffuse a situation. I don't think it's a silver bullet, but it can help you to solve it. Increasingly IP is important. If you're going to contribute it, what's the value? Are there any limits on it? How do you protect your IP? Who will own the improvements? How will that be licensed? So I think they're some of the key issues in a joint venture.
And the box to the right is not necessarily about negotiations directly, but it's like Mark mentioned, putting together the management and the board. These titles do come with certain power, so figure we put a little bit of information here. And obviously, some of these issues probably have already been discussed when it got to the term sheet phase, but some of them probably have not, such as the dealing with deadlock.
I'd say the right to access of information, it's nice to have in there, but I wouldn't think, if there's a real dispute and the Chinese partners controlling the joint venture, you're not going to be able to go in there with a group of mercenaries and get all the reports. So, it's good to have in there, but, you have to be realistic what's going to be possible.
Yeah. These are some the last few here that we thought we should highlight: equity transfer, compliance, and exit. Mark.
Yeah, so quickly on that. So, how it will be transferred, equity dilution. These things, because joint ventures are very static, you don't really need most of these things because everything must be consensual. But if you want to have the right to dilute the other side, you should put it in, but also realize it will still be a bit of a negotiation. But like I say, if the contract is clear enough, it helps those negotiations. Compliance, you'll probably want that in there. Just for your own, you might need it because for your own overseas requirements, but also it's something to point at. And it's, the thing with compliance is if you set it up early, then it's okay and it can do its job. If you only try to insert it once there's a problem, there's a lot more resistance. So I think that's why you set up early. And then exit, I think we discussed it already. Joint ventures have a lifespan. How do you strategically put yourself in the best position for your eventual exit? Because most people will exit at some stage.
Yeah. So again, there's this tension between trying to get everything on paper, but at the same time remain flexible enough. There's a nice little case study here, which we won't get into because of time, but if you are looking for a good time, you can check it out in the PDF I sent later. So Mark, we have maybe about half a dozen issues, I think. So maybe we need to rattle through them, maybe about a minute each. So these are the issues with dealing with the actual contracts. So first issue, Mark, just poor contracts.
Yeah, so I think I already discussed it a bit. I mean, I think, contracts are not, you have to have contracts. People always say, oh, this joint venture is like a marriage. Yeah, it probably is. Some of them won't work out. Probably most of them won't work out. And no marriage lasts forever because, at a minimum, one person's going to die. So it's good to have a prenuptial agreement. So I think the contract should be, while you're talking about how great and successful you're going to be, maybe you should also work out how you can exit unilaterally, or what's the best way to deal with that, just in case things don't work out. And then I just put there, we won't go through them all, but there's some important issues on this which are controversial and you really have to fight on. And then there's things people fight about for a long time. It's really, the style of the contract. Like I want everything in bold, anything which will annoy the Chinese partner, let's put it in bold and uppercase so I can really make sure I annoy him and draw his attention to it. Not required in China. So, I don't know, maybe in America it helps you if you go to court. I don't know, but in China it does make a difference. So think about that. Choice of law, most of these things will need to be Chinese law, but these are some of the issues. I think, sometimes you'll need to do it, but sometimes if we have, things which don't need Chinese law, I still think if it's being primarily, done in China, let's say a technology license agreement, it's better to have Chinese law, possibly even Chinese courts. I know that's a later slide, because having a foreign law like English law or US law just makes it more difficult. And, if you have New York law, you probably have New York court, and that will just not be enforceable. So, yeah, next slide then I think.
Yeah, the courts.
Yeah, so I think that just followed it. I mean, we had a case for many, many times. I saw someone here, arbitration versus court disputes. Look, I think for joint ventures, I've never seen anybody not agree dispute resolution. I think everyone has arbitration. But, let's say that technology license agreement I just mentioned now, if you're the technology licensor, you probably would not mind Chinese courts because it's quicker. They can do freezing orders. They're cheaper. And I think they're not bad. It will depend on the thing. I think they will be as difficult to enforce as the arbitration award, to tell you the truth. So I would go that way. I would go for Chinese courts more often. But very often when I say this, the client just shakes their head and thinks I've gone local. So,
I mean, speaking of IP.
Yeah. So regulating the ownership is very clear. Like I said, joint ownership might seem fair. That obviously is still my trauma at reading that Harvard Business Law article from 18 years ago. But I think, it's important to think a bit about the implications of joint ownership, and it's not going to be necessarily fair. So let's say if you're licensing technology to a Chinese company, they commercialize it, they change everything, they fund the R&D. It's probably not fair that you jointly own it. It might be fair that you get a license to use that technology outside of China.
Yeah. Oh, and before I forget, Robin, I think we have a different episode just solely on litigation, and we talk about arbitration versus courts. So remind me if to send you a link to that video. So issue 5, Mark, what's my contract worth?
Yeah, I mean, it's always funny when people have contracts. Okay, joint venture contracts, it's unlikely, but supply contracts and things like that. Yeah, we've seen contracts, signed by a Chinese company with the name only in English, no registration number, and difficult to know who they are. And then it's signed by somebody called Tony Wang, who again, we have no idea who Tony Wang is. It's not his official name. Plus, China probably has, 100 million Tony Wang. So, yeah, I think it's important to make sure who the person is, ID number, company's ID number. Chinese chop is always nice to have on there. Whack that on there. And also maybe it's good to see if the company exists. I mean, we did have a client last year who asked us, to review the contract. We had a quick look at the Chinese partner to see, if there's anything exciting, and it was pretty exciting. The company was liquidated, went into bankruptcy 2 years before, so they were still signing contracts. So yeah, these are the things you should perhaps look at.
Yeah. So going from the basic, very fundamentals to the amorphous here, think beyond your claims, thinking beyond just the black and white.
Yeah. So I think here, think a bit beyond the contract. Think a bit about, like, a lot of joint venture contracts will have lots of things that are put together. So let's say there's a car supplier joint venture. Maybe the German parent will have a supply of components agreement. There might be a technology license agreement. There may be a trademark agreement. It's probably not great to have each contract with a different law and a different dispute resolution, because if you're going to have a problem somewhere, you're probably going to have a problem everywhere. So think a bit about those things. Liquidated damages, it's worth putting in, but you have to be aware that there should be some concept, otherwise they can be overturned. Maybe if you're selling equipment, think about retention rights. So think a bit beyond just the agreement. Think a bit creatively how to best deal with it.
So we have, I know we only have 4 minutes left, but Mark, maybe we just go through a very quick case study on, putting all of the lessons that we've talked about from part 1 and part 2. I really wanted to get to this part because it kind of brings it all together. So here we have a case study where a multinational dairy company looking to enter the China market, selling some of their higher margin retail products. And maybe, Mark, you want to go over a little bit some of their specific challenges.
Yeah, so I think, look, there was also a lot of people coming into the market a few years ago. They had limited prior experience dealing with it. They had no idea about how to distribute retail products directly in China. And so their whole brand story was about quality, safety, and freshness. And they also placed a great importance on the supply chain management. And they had a preference for selecting a partner who could do almost all of the distribution for certain product lines. And so I think they had to find the right kind of partner distributor, somebody who knew how to do this business. So food was important. Somebody who had an established distribution network, not just in that first tier market because they were already saturated, but the second tier. Had a good reputation of product safety because the product was temperature and environmentally sensitive. So it was a new type of product, fresh milk. And then they were also motivated to find somebody who could help develop together with them and move quickly to market before other competitors would get in. Okay. And so the distributor commented on the Chinese text, updated the English. There was a mixture of legal and commercial changes. The commercial terms were negotiated, and then the contract, form was quite, clear. It outlined the different responsibilities and also had a lot of mechanisms about reporting performance reviews.
So here we have some of the key contract terms that were negotiated. I don't think we need to go through each one of these, but it is, or maybe Mark, you do, but I just want to, everyone, I'll let everybody know that, because I know we're out of time here, but these terms, I made sure to include them into this case study because I wanted everyone to kind of have some type of takeaway here of how everything we've talked about is put together. And we know that this is a dairy company. It's not necessarily, your technology company will have something different, obviously, but these are the types of,
sorry, I can't talk right now.
These are the types of issues and these are the types of items that, one should be cognizant of and at least anticipate. So let's just Mark, just wrap us.
So I better close up because we have to go on the other thing. So I think basically this is one of those few case studies where things were positive. So actually aligning the commercial interest, finding the right partner made sense. The key negotiators were on the ground in China. They were directly involved in negotiations from both sides. They had a collaborative approach, and they translated everything into English and Chinese every round. The Chinese side was running it more, and there was no misunderstandings, and things happened quickly, and it went well. So sorry, Sean, I got to leave.
Yeah, well, thanks a lot, Mark. Thanks everybody for joining. I'll send a copy of the presentation. Thanks everyone.